Mr. Chairman. Thanks for the excellent hearing, and thanks to all the panelists, and thanks for your patience as this is going to be the last round of questioning. I do want to just follow up a little bit, Ms. Eberly, with the comments and the feedback I'm getting from these community banks supervised by the FDIC. And one of the common themes, in addition just to the compliance costs and the intrusiveness of some of the exams in terms of taking personnel off of the actual business of banking, which is lending, is the idea among particularly small, non-systemically important institutions in rural Kentucky that there is a trickle-down effect. There's a trickle-down effect with these regulations where regulations that were maybe originally intended for large, systemically important are being applied to smaller banks, often in the form of the examination process, where examiners are coming into the small bank, identifying those regulations as best practices, even regulations that specifically don't apply to the smaller institution. And yet, because these are quote-unquote best practices, these small institutions with small compliance staff are being asked to nonetheless comply with the larger standards. Can you comment on that?
Certainly, that would not be consistent with our policy. So,
yeah, I know it's and that's been your testimony all day today. It's not consistent with your policy. I heard that with respect to Congressman Rothfuss's example as well. It's not consistent, and yet we're hearing from our regulated constituent banks that that is in fact happening.
I would ask you to ask them to contact me.
Okay, and here's and that response I heard as well. And just forgive me for my frustration, and I'm sorry I appear frustrated, but here's the problem. What they tell me is they don't want to be identified. They don't want to be identified because they feel it's intimidating. And so when I say I am disappointed that you all don't want maybe even a version of the Westmoreland bill that is a fair exam reform bill that would provide for independent review of your exams, the reason why that's necessary is because our institutions don't want to be identified, because they fear retaliation, because there's not an independent review of your exams. So do you have any sympathy for that concern, that if we do identify our banks to you, these banks who have concerns, that you will take a retaliatory approach and there is no legitimate objective appeal? It's just a rubber stamp affirmation of the previous review by your examiner.
So examination findings have been overturned where they're incorrect. We absolutely do that in the appeals process.
How often is that?
It's not frequent. There's not a lot of appeals that come forward in the formal process. Issues are generally resolved at the lowest level.
Well, let me give.
But we really guard against the idea of the trickle down with statements of applicability on all of our financial institution letters as to whether applicable to banks under $1 billion. There's a review process for every report of exam to make sure that it is consistent with our policy. So if that is happening, it's very troubling to me, and I really would want to talk to the institutions. It would be very helpful.
Well, we'll continue to work on that. And I want to give the regulators, the OCC, Fed, FDIC, some credit, because I heard in your testimony that you were interested in a longer examination cycle for highly rated community banks. I have that provision in legislation I've introduced called the American Jobs and Community Revitalization Act. The proposal that I have would take it up to $1 billion. So banks under $1 billion in assets that are highly rated could move to that 18-month exam cycle. So I appreciate the recognition that that might be appropriate in a good area of agreement between those of us who want to see regulatory relief and the regulators, and I'd encourage you to continue to take that position. Just really quickly, with the time remaining, let me turn to Mr. Silberman and indirect auto lending guidance. Was the Bureau's objective to change the behavior of many of these auto lenders?
The Bureau, no, sir. The Bureau's objective was to allow the indirect auto lenders. I'm sorry, could you repeat the question?
Yes, the question is, was the Bureau's objective in the guidance, in the bulletin, was it to change the behavior of auto lenders?
So if we're talking about indirect auto lenders, the Bureau's objectives were to
not dealers, lenders within your jurisdiction.
Indirect auto lenders, right. So yes, the Bureau's objective was to let the indirect auto lenders know our understanding of the law, so that when we came in.
Why are you doing that so that you can change their behavior?
It depends on what their behavior is, sir.
Okay, so if this is just a restatement of existing law,
yes,
you're not trying to change behavior. If you're trying to change behavior, You're in violation of the Administrative Procedures Act because you're not doing this through notice and comment rulemaking. And I would submit that you violated the APA on this, and I would encourage you to do a rulemaking on this. And I've run out of time, but appreciate the chairman's indulgence.